Welcome back. This morning, we're shining the spotlight on the controversial evidence at the center of OnlyFans model Courtney Clenney's homicide case. Clenney is accused of stabbing her boyfriend Christian Obumseli to death inside of their Miami condo back in 2022. The state says it was murder. Her attorneys say it was self-defense. And now they want to keep out a certain piece of evidence from the public eye. Take a look.
So for you guys, it's just essentially the one document.
It is. I think that protects it, as long as we are not discussing like the absolute details of what's included. We can talk around it in generalities, but I don't see, and I haven't heard Mr. Quinnen point to anything that makes me feel like we can't do it and just seal that one document.
All right, so the evidence is a checklist of sorts developed when prosecutors went after Clenney's parents for having what they said was Christian Obumseli's laptop. Well, that turned out to be a big mess. They ended up having to drop those charges. They got into things they shouldn't have gotten into that were privileged information belonging to the defense. So this hearing was had. You're going to see all of it coming up, but there won't be a decision from the court as to what comes in, what stays out until the new year. So essentially, the defense team is saying that they had a game plan that the prosecution looked at and shouldn't have looked at, and they shouldn't be able to publicize this and put it in the court case. So let's dig in on that. So pleased to welcome in Courtney Clenney's defense team. They are heavy hitters in Miami, attorneys Sabrina Puglisi and Frank Prieto. Good morning to you both. Okay, so let's start with just a little bit of clarification on what exactly they got. We've been calling it kind of your game plan that they got, but maybe a better way of saying it. What exactly did the prosecution get a hold of through that whole laptop case ordeal that they shouldn't have? Ladies first, Sabrina Puglisi, I'll start with you, please.
Thanks, Julie, and happy holidays to you. So, yeah, not just a game plan, but really an evaluation of our case, and then we laid forward our thoughts, our mental impressions of the things we need to do in order to prepare for trial. As you stated, once again, this is the prosecutor getting into things they shouldn't have. It was very clear in the document that was sent. It was actually titled Things to Do Privileged, and that's because the document was both attorney-client and work product privileged.
So it's marked privileged, and yet they looked at it? Frank Prieto, would you speak to that? What exactly did they do here?
Sure, Julie. So you may recall, and your viewers may recall, that the prosecution in the case admitted that they did read a text which the court found to be attorney-client privileged, which was the basis for them having to drop the computer case. And that prosecutor indicated to the court at several hearings, I only looked at the text message. I swear I did it, but you could put me under oath. And, we probably should have, because it came out later that he came across an email through a warrant that they served, which we think was inappropriate. But it was that email that Sabrina just described. And he not only did he read it, he went through it, he opened the attachment, which was labeled privileged, and then he forwarded it to law enforcement. And then we found out he actually showed it to other prosecutors. I mean, it boggles my mind.
Yeah, I mean, this is really bad. I mean, there were ethical constraints, as you both know, that prosecutors have. A special set of rules, actually, that they have to follow, that defense attorneys don't. So to then disseminate this beyond viewing it, so then did it get to the court files somehow? That's what I'm curious about, because we understand this hearing, there was a lot to be said about sealing and unsealing this document. Sabrina, what exactly happened? Did they somehow attach it to a motion or something?
No, Julie, they did not. What it is it's evidence in our motion to depose the prosecutor and our motion to disqualify the state attorney's office. We felt it was needed for the judge to be able to appreciate the full ramifications of what the state did when they violated attorney and work product privilege. And so we needed to attach it as exhibit to show the court, but obviously we can't show it to the public.
Gotcha. Okay, which I completely understood. Attorneys should know better when something is work product, when something is privileged. it's just hands off. You just don't go there. So you all had a hearing, argued these things. We recorded the hearing. We're going to play it in our next hour. So our viewers will get to see everything, see all the arguments, and perhaps it'll make a little more sense. I think one of the biggest burning questions is, when is this case going to trial? Frank, what can you tell us about that? Do we have a court date in 2025?
Yeah, Julie, you know, this breach of the defense camp by the prosecutor's office here in Miami-Dade has really delayed things. We've taken the position, and I think the appropriate position, that these prosecutors should not be on this case. So kind of, you know, this whole situation has kind of pumped the brakes. You know, our client has been in for over 2.5 years now, August of 2022. She wants her day in court. She's innocent. The actions she took that night were to defend her life, and we need to get to trial. But this looks like this is now summertime, and I know Judge Cruz has difficult decisions to make here, and she's doing the best and trying to move this forward. But it's really been delayed, so it's really wearing on Courtney's mental health.
Sure. No, understandably so, Frank. So really, this is important for us to know that really the remedy you want is for them to be disqualified. You're asking for that as well, is for this to be remained or kept under seal. I understand it's not public now, part of the court file, as you explained, but let's hope we get a decision on this soon. Any idea when the judge will rule? Sabrina, did the judge give you a target date for a decision?
We know she's ordered the transcripts. It's 10 days, so that's around January 3rd, and I'm sure she'll rule sometime soon thereafter. She really does want to push this along. So, you know, look, if she is going to disqualify the state attorney's office and or any of these prosecutors in the case, she knows that she needs to get that done quickly so that we can get this case moving along.
Right. They might get DQ'd after all of this. Great talking with you both. Happy holidays. Sabrina Puglisi, Frank Prieto, thank you so much for making time for us.